Massachusetts has one of the oldest and most aggressive habitability enforcement systems in the entire United States. If you're a landlord in the Bay State, you are operating in a legal environment that gives tenants extraordinary protections, and the consequences for noncompliance can be severe. The cornerstone of Massachusetts habitability law is the state sanitary code, specifically 105 CMR 410, which is the minimum standards of fitness for human habitation. This code is enforced by local boards of health and is incredibly detailed. On top of that, Massachusetts general laws. Chapter 239, Section 8A, provides tenants with a powerful defense in eviction proceedings when habitability issues exist, and the implied warranty of habitability has been firmly established in Massachusetts case law since the Boston Housing Authority versus Hemingway decision in 1973. Under the state sanitary code, landlords must maintain the property in compliance with a long and specific list of requirements. You must keep the structure watertight and in good repair, provide adequate heating capable of maintaining at least 68 degrees Fahrenheit from September 15th through June 15th, one of the longest heat seasons in the country, supply hot water at a minimum of 110 degrees Fahrenheit at the tap, maintain plumbing and sewage systems in proper working order. Ensure electrical systems are safe with adequate outlets in every room, provide and maintain smoke and carbon monoxide detectors, keep the property free from insect, rodent, and pest infestations, maintain all means of egress in safe and operable condition, ensure adequate natural light and ventilation in habitable rooms, and provide kitchen facilities with a working stove and refrigerator unless the lease specifically states otherwise. What makes Massachusetts truly unique is the enforcement mechanism. Local boards of health have the authority to inspect rental properties, issue orders to correct violations, and impose fines for noncompliance. If a landlord fails to comply with a Board of Health order, the municipality can make the repairs itself and place a lien on the property to recover the cost. In extreme cases, a property can be condemned and tenants relocated at the landlord's expense. Massachusetts tenants have some of the strongest remedies in the nation. Under Section 8A, if a tenant is facing eviction and can demonstrate that the landlord knew about code violations and failed to correct them, the court can reduce or eliminate the rent owed. This defense has been used successfully in thousands of eviction cases across the state and is a powerful incentive for landlords to stay on top of maintenance. Tenants can also withhold rent in Massachusetts, and the state is one of the few where rent withholding is well established and regularly upheld by courts, provided the tenant can show that the conditions materially impair health or safety, the landlord had notice, and the tenant did not cause the problem. Tenants can also pursue the repair and deduct remedy, file complaints with the Board of Health, and bring private lawsuits seeking damages, including up to 3 months' rent or actual damages, whichever is greater, under the Consumer Protection Statute, Massachusetts General Laws, Chapter 93A. That Chapter 93A connection is significant. Massachusetts courts have held that a landlord's failure to maintain habitable conditions can constitute an unfair or deceptive trade practice. This opens the door to treble damages, meaning the court can triple the damages awarded, plus attorney's fees. Very few states expose landlords to this level of financial liability for habitability violations. Massachusetts also has robust anti-retaliation protections under Chapter 186, Section 18. Landlords cannot raise rent, reduce services, or attempt eviction within 6 months of a tenant exercising their rights, including making a habitability complaint, contacting the Board of Health, or joining a tenant organization. Any adverse action during that 6-month window creates a presumption of retaliation that the landlord must overcome. One more thing, Massachusetts has some of the strictest lead paint laws in the country. Under the lead law, landlords must de-lead any unit where a child under 6 resides. Failure to comply can result in significant fines and personal liability if a child is harmed. This applies even if the landlord didn't know about the lead paint. Liability is strict. For the complete guide to Massachusetts habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay protected in every state.